Judge of the High Court. Before we delve into it, you can confirm to us your county.
My lady, my county is Siaya.
Siaya. And your ethnicity?
Your Lordship, my ethnicity is Luo.
Luo. Thank you very much.
Thank you.
Commissioner Mashadia will take it from there.
All right, just a few questions, my brother. Now, I'm looking at your CV, and what I've noted is that you started from private practice, then moved to police service, then became a public prosecutor, then moved to judiciary, then after that moved out again and went to the Iebc, the Electoral Commission. Now, so I'm trying to understand what exactly is it that you are pursuing, because, you know, there doesn't seem to be one line that you are pursuing which moves to your career objective, you know. So could you explain to us this movement from one area to the other, then to back to this, and then, you know, it seems to be a little bit confusing to me. Not to say that there's anything wrong with that, but it's just for us to understand, because when we are looking for somebody who is really committed to pursuit of justice as a, you know, as somebody who will be determining matters as a judge.
Thank you, Commissioner. My drive is pursuit for excellence in public service. Save for the first 4 years that I was engaged in private practice, Commissioner, I have been in public service for 17 good years, and my cycle of operation has been within the court situation. Even as I pursued training with the National Police Service, I attained competencies in investigation and prosecution that was necessary for the discharge of my duties within the court precincts as an investigator and also subsequently as a prosecutor. Again, when I joined the judiciary, the drive was to serve in the justice sector, having practiced as an advocate, litigation counsel, having acquired wealth of knowledge and skills in investigation and prosecution, basically having gone round the legal cycle, I felt that time was ripe for me to sit in the bench to deliver justice. Commissioner, I left the judiciary, not in a bad way. If you look at my resignation letter, there is very clear indication of a desire to come back to the judiciary. In the last paragraph of the resignation letter that I tendered to the judiciary, I was attracted by an advertisement by a sister commission, and I looked at the qualifications that were indicated in that advert. If you permit me, Your Lordship, they needed an advocate then of a minimum of 8 years experience. They needed an advocate who had trained as an inspector of police. They needed an advocate who had experience in adjudication of cases, either as a magistrate or a member of a tribunal. Your Lordship, I looked around the country, knowing the colleagues that were in my class at the Kenya Police Training College, Kiganjo, and I discerned that we could probably have been only 3 people in this country. So I did not want to let down public service, and that is why I joined the Iebc. Again, as a matter of career progression, the mandate of the Manager Investigation and Prosecution, the office that I occupied, was countrywide. I was in charge of investigating all election offenses and prosecuting all election offenses in this country under the Elections Act then, before the mandate was changed to the Office of the Director of Public Prosecution under the auspices of the Election Offenses Act. So I looked at that as an opportunity to progress. Your Lordship, I believe I have reached my optimum at the Independent Electoral and Boundaries Commission as the Director of Legal Services. There is no opportunity to move upwards along the line of legal services. The opportunity, with humility, Your Lordship, is in this commission, to the State Office of a Judge of the High Court. Thank you.
Yeah.
Your Lordship.
I don't doubt about your ability at all. I don't doubt about your integrity. It's solid. I don't doubt about your competencies. But see, in view of the fact that there are many who have also applied, you'll appreciate that one of the determining factors of success in any position that one applies for is the passion for that particular position. So which brings me to the issue that, yes, it's okay, you want to serve in public service, and you've served diligently. That is no doubt.
Thank you.
But why a judge? Because see, you've also said that for you, you've reached the apex, and there's no other opportunity for you to progress in Iebc. But you see, that's not enough for us, because that's for you. For us as JSC, we are not looking for somebody who's looking for their own career progression because they've reached the apex. We're looking for somebody who will satisfy us that they have
litigation in constitutional matters, judicial review. I have also been able to acquire competencies in the area of impartiality. Being the captain of electoral dispute resolution at Iebc, I have mastered the art of impartiality in deciding election, pre-election related cases. I'm also an independent-minded person, Your Lordship, and that is what has enabled me deliver at the Commission. At the Commission, we interact with stakeholders who are politicians and who will always want it to go their way. So my solid basis of independence, integrity, has enabled me to discharge my duties without being compromised at all. I'm also a very diligent person, and I know judgeship requires diligence.
Thank you, Honorable Chair. Mr. Otieno, indeed, looking at your letter of application and your CV, you've gone against the grain by being in the judiciary, going to serve in the police force, serving at Iebc, etc., etc., which many of us who are trained as lawyers do not seem to do. And that I want to commend you for really going against the norm. But one or two questions for you. I noticed that you've also at some point been a prosecutor. Yeah? The Penal Code provides different kinds of punishments for a person who is convicted of a criminal offense. Just name a few of them, say about five or so. The different kinds of punishments that can be meted out.
Your Lordship, indeed the Penal Code avails a raft of sentences that can be meted out. There is the sentence of imprisonment. There is also the sentence of payment of a fine.
Correct.
There is also the sentence or an order for compensation.
Right.
We also have the sentence, suspended sentence. Can have a suspended sentence.
Yes.
When the sentence is for not more than 2 years. We also have a sentence based on conditionalities, discharge on certain conditions.
Very well. So imagine yourself as a High Court judge, you're conducting a murder trial, and at the end of the trial, you find the accused person guilty of the offense of murder. However, this accused person is below the age of 18 years. How do you proceed after that?
Your Lordship, I have to be satisfied, one, that the person is below the age of 18 by directing an age assessment on the convict. And when the age assessment report is presented, I'll consider it. I'll also require the probation department to do a pre-sentence report about the convict.
So
If
fair
I'm-
enough, the person is below, it's been certified that the person is below 18 years.
Thank you, Your Lordship. I will not commit that person to prison.
Where do you
We
take
have
him or
postal
her?
institutions, Your Lordship, that take good care of minor offenders or offenders who are minors below the age of 18.
What about the sentence to serve at the president's pleasure?
Yes, the President appoints the Power of Mercy Committee. That committee has the mandate to consider clemency on convicts. Probably it could be one area that would be worth considering, but that is based on the mandate of that committee.
There is some school of thought that sentencing an accused person to serve at the president's pleasure is tantamount to the judiciary ceding its mandate on sentencing. What are your views on that?
Well, in the period preceding the promulgation of the Constitution of Kenya 2010, the power of mercy that is exercised by the President on recommendation by the committee would sit well under that dispensation. But with the new Constitution, I want to believe that that is an area that needs to be looked at. Probably the courts need to develop indigenous jurisprudence along that line, because then the person serves at the pleasure of the power of mercy, is at the pleasure of the executive. Yet our Constitution, which adopts the doctrine of separation of powers under what Montesquieu calls trias politica, would not be fulfilled by allowing the head of the executive to exercise judicial power.
So you think there is some form of interference there?
Certainly, I am persuaded, Your Lordship.
Thank you. That's all from me.
Yes, now that you have gone to the Constitution, I think I will begin there by asking you, what is your understanding of the supremacy of the Constitution, and ask you to give me 4 aspects based on your understanding why the Constitution is supreme. Give me 4 instances.
Your Lordship, the Constitution of Kenya is the supreme law of the land. The Constitution itself declares this supremacy under Article 2 of the Constitution. The Constitution is supreme because it espouses principles and values that are necessary for good order of the country. The Constitution also...
There are other laws that espouse values, not just the Constitution. So I want you to zero in on why is it supreme.
Your Lordship, yes, there are other laws that espouse those values and principles, but then those laws derive their legitimacy from the Constitution. So even as they replicate the provisions of the Constitution, the legitimacy of those laws is in the Constitution. The Constitution also is supreme because it creates government, essentially the 3 arms of government. It's the basis of governance of this country. Without it, there cannot be...
Yeah, that is one. It gives authority to the levels of government. Number 2.
Your Lordship, the Constitution also is the foundational document on fundamental rights and freedoms. These are rights and freedoms that are inalienable and that are bestowed on every citizen of the country to enjoy without unreasonable limitation. So insofar as the Constitution provides the rights and the fundamental freedoms, it is supreme.
So, any other?
Your Lordship, the Constitution is also supreme because it has objects that unify or put together the country. Looking at the preamble of the Constitution, for instance, issues about inclusivity, issues around ethnic, social, and religious harmony of the country is derived from the Constitution.
I would have expected you to talk about inconsistencies, if there are any inconsistencies with the Constitution.
Yes, Your Lordship.
The Constitution remains supreme.
Yes, Your Lordship.
We can leave that area and go to another area of practice. If you are successful in this bid and you are sent to a court station, what are the 5 things that you would do to make your station efficient?
Your Lordship, there are quite a number of things that I would do, and I would seek guidance from the blueprint that has been initiated or promulgated by the judiciary, STARJ, the Social Transformation Through Access to Justice Blueprint. I would first of all engage my staff to identify their various competencies so that I can be satisfied that each staff is indeed serving in the appropriate area of competency.
Okay, those are 2.
I would also engage the environment around the court so that because the court does not operate in exclusion, I will engage the court users committees that are in place. I would also engage any institutions that exist as alternative
stakeholder engagement.
Stakeholder engagement.
Yes.
I would also,
Number 4.
Your Lordship, I would also ensure that there is good collaboration as between the partners of justice that exist within the court's jurisdiction, such as the Office of the Director of Public Prosecution.
Yes.
I would also explore the avenues available for alternative dispute resolution and also alternative justice systems that are consistent with the constitutional purposes.
Okay, Justice Majanja.
Yes, good morning. Just one question.
Good morning, Your Lordship.
I was reading a story the other day in the newspaper, and this doctor was complaining that he had been imprisoned for life for robbery with violence after he had been found with a mobile phone. So can you just explain to us why would he have been convicted?
Your Lordship, I would think that probably the mobile phone may have belonged to the deceased person, and therefore that was the connection between his possession of the mobile phone and the trial. Probably, Your Lordship.
So what do we call that doctrine?
The
one that applies that kind of...
The doctrine of recent possession.
Okay.
Yes.
So would it make a difference if the phone was found a few days after or a year after?
It would make a difference, Your Lordship, because the doctrine of recent possession applies when the time between the commission of the offense and the time of arrest or recovery of the property is short. If the period is prolonged, then there could have probably have been intervening factors in between that would certainly not render him culpable.
Okay. And finally, can you illustrate to us the difference between horizontal and vertical application of human rights by way of illustration?
Thank you, Your Lordship. Horizontal application of human rights basically is from top to bottom. It is about human rights as between the common consumers of justice, that is persons, and state power or public power. Ordinarily, the Constitution, that is vertical. Horizontal is between the persons, inter se, and also between persons and other entities such as corporations or multinationals. Horizontal application, Your Lordship, may apply in the instance of a company, for instance, that sets up a factory, and the factory does not undertake what is called environmental impact assessment of its activities. As a result of its operations, there is, for instance, effluent from the factory that then interferes with the environmental rights of persons who reside or the health rights of persons who reside within the precincts of the factory. Thank you, Your Lordship.
Thank you, Honorable Chair, CJ. Council?
Yes, Your Lordship.
Thank you very much. For me, I also join hands with the commissioners who appreciate that that you did something unique, and I think you should be commended for that, joining the police force, the National Police Force. That's part of a very important institution in Kenya, and you have gone from place to place, but you have remained within the legal sector.
Thank you, Lordship.
So I commend you for that. What I will ask you, I saw that you mentioned STAJ. One of the principles of STAJ is access to justice. And I can see that you are an expert, if I would say from your writings, on election matters. You have participated in election cases and so on. So tell me about the importance of access to justice in terms of electoral integrity.
Thank you, Your Lordship. Access to justice is a constitutional prescription. Elections take place within the ambit of the Constitution. I would refer to the provisions of Chapter 7 on representation that enlists the guiding principles of an electoral system. Integrity is a very key factor. Integrity of the electoral process by persons who conduct the elections, so that those who...
How do you access justice?
Yes.
How do you access justice towards attaining election integrity?
Yes, justice is attained by allowing persons who participate in elections and who lose in those elections to be able to petition the results of the elections. And the justice architecture is such that there are appellate opportunities available to those who lose in the election petitions, even at the first tier. So there is an opportunity for persons who participate in elections and lose, or persons who feel that the elections was not conducted in a free and fair manner to access justice through the court system. There's also access in the pre-election period, Your Lordship, through committees, for instance, the Iebc Dispute Resolution Committee that the Supreme Court has recognized as a very, very effective pre-election dispute resolution forum.
Okay, thank you. I can see one of the documents, in one of your documents presented,
Yes, my
we
lord.
have the Global Commission, the International Covenant on Civil Rights and Political Rights.
Yes, my lord.
It was done by which people?
It's a UN
UN.
convention.
And one of the principles they set out is that the rule of law and access to justice is a cornerstone of electoral integrity.
That is true, Your Lordship.
So, apart from the access, what about the remedies?
The remedies, Your Lordship, that are available are many. For instance, if the judiciary or the Justice Resolution Committee of the IEBC finds that probably there were election transgressions that were committed, then remedies available. For instance, in election petitions, an election can be nullified. In an election petition also, there can be a declaration by the court on who actually won the elections.
So do you agree that apart from the accessing the justice system, even the remedies, finally, at the end of the day, they are part of the access, the right to access to justice?
Very well, Your Lordship. I agree entirely, because that is the end result of the dispensation of justice. Justice is hollow if there are no remedies that avail.
Thank you. I wish you all the best.
Thank you, Your Lordship.
Thank you, Chair. Good morning once again, Council.
Good morning,
I
Commissioner.
remember when we started our practice, we were with you in Kisumu, and we used to come to you for precedence, and I'm happy that you continue writing well. I have gone through your sample writings. You write very well. Though I have concerns with regards to 3 of your sample writings. One is an internal memo to the chairperson of the IEBC. Did you get the necessary authorization for you to then present this internal memo to the Commission as a sample writing?
Yes, Your Lordship. I got authorization from my supervisor, that is the Commission Secretary.
Is it among the documents you presented to us?
The
authorization, because an internal document should not be shared unless you get prior authorization. Public document. Yes.
I do not have a document giving me authority, but it is an advisement that I authored.
Which
and
is
as
okay,
counsel-
which I say it's okay, it's well written, but just how you then present it. It's supposed to be internal to the chairperson, and you have here 11 commissioners, member of staff, reviewing an internal memo without an accompanying authorization from the CEO.
I agree, unfortunately, yes, Commissioner, but I took it that the Judicial Service Commission needed to know how well I write, how well I articulate issues, and how well I advise on legal matters.
Okay.
And that's why I picked on it, but I agree there's no authorization.
Okay, thank you. And then the other sample writing is election petition in Hola. Again, the author is the firm of Abdul Hakim and Company Advocates, not yourself, though you have deponed to an affidavit, but down under it, it's written as drawn and filed by Abdul Hakim and Company Advocates, not you.
Yes, Commissioner, if I could explain, I am the deponent. It's an affidavit. Whatever is expressed in that affidavit is my thought and my appreciation of the law. As a commission, we contract external law firms to represent us in a number of cases. although I also represent the Commission, and I've represented the Commission up to the Supreme Court in matters. But because of the multitude of cases that present during the election period, we contract, and in that case, we contracted the firm of Abdul Hakim to represent us in that election petition. It was an MCA petition.
Yes.
But I presented it because I wanted Your Lordship to explain my in-depth appreciation of the election under the party list framework.
Which is okay, but what my concern is, it is drawn and filed by. So the author here is the firm of Abdul Hakim.
Yes,
Drawn by that
legally, yes.
firm.
Yes,
So
legally,
there's
I agree,
also,
Commissioner.
we are not able to say whether it is you or the firm that, okay, based on the information, it is the firm that drew it. And then lastly, the last sample writing